I request everyone to kindly settle down. Please maintain silence. A very good morning to one and all present here. I welcome everyone for this special lecture organized by our college in association with the Trademark Registry, Department of Promotion of Industry and Internal Trade, Ministry of Commerce and Industry, Government of India. This is an IQAC initiative regarding the National Awareness Program on Intellectual Property Rights. Now I request our beloved principal, Dr. S. Raju, to introduce the chief guest and the resource person for today's event.
Hello, Namaskara. Good morning, everybody. Respected guests and distinguished speaker of the day, faculty members, and my dear students. JSS Law College organizing several innovative programs. This one such program we are organizing this IPR awareness program in association with Trademark Registry, the Department of Promotion of Industries and International Trade, Ministry of Commerce and Industry, Government of India, and also as a part of IKC initiatives, we organizing this program jointly. This national level awareness program on IPR, that is intellectual property rights, is considered to be very important, especially is considered to be one of the current issues and emerging areas in the field of law. We organize similar programs and also on various aspects of besides the interdisciplinary aspects of law. I am very happy to introduce and welcome the distinguished speaker of the day. Is none other than Mr. R. Venkatesan. He is the senior examiner of trademark and geographical indication, IP Office, New Delhi. So, Mr. R. Venkatesan, a senior examiner of trademark and geographical indication, currently is working in the government institutions, that's an intellectual property office, and he has been associated with this institution since 2010, and he has served more than 12 years of service. Sir has previously practiced as an advocate before the Honorable High Court of Madras for about 7 years, and we are happy to have this an intellectual, and what we are taught in the class is only theoretical, but he is going to enlighten us on the practical component or aspects of IPR. Sir, on behalf of our JSS Law College and your department, I extend a hearty welcome to you, sir. I also welcome our CE. Now we are busy with the staff meeting. He is about to join. So in absentia, I welcome Professor K. Suresh and Mr. Jagdish and his teams. The students volunteer are very actively involved in organizing this program. So also extend a warm welcome to them, and also welcome all of you for your active involvement. Extend a warm welcome to one and all. Thank you.
Thank you, sir. I extend my warm welcome to our beloved principal, Dr. S. Raju. I welcome dear teachers and the students gathered here. Now I request our chief guest and the resource person for this lecture, Sir Mr. R. Venkatesan, to take over.
Respected principal sir, respected Jagdish sir, and their esteemed students, and all gathered here. Good morning, and on behalf of the Government of India and the Intellectual Property Office, Chennai, I am thankful for giving an opportunity to conduct a program with respect to intellectual property awareness. We planned this program to reach 1 million students this year. We started from December. This will continue until the end of August. So our motto is to reach each and every corner of the country, not only in South India, all over India we have started this program. It's going well, and once again I'm thanking your institution for granting an opportunity to have a program in your institution. Thank you one and all. Now, before you step, intellectual property awareness mission, as mentioned earlier, it is a mission started in the month of December, and then we reached almost half of that portion of people, around 5 lakhs. Then there is a office. We got 4 jurisdictional office. All the metropolitan cities having our offices, and one more in Ahmedabad. In Ahmedabad, we are dealing with the trademarks only. In rest of the 4 metropolitan cities, we are having a patent, trademark, design, copyright, and then geographical indications. These are all the subjects we are going to discuss today. We'll see the subjects one by one. Before going to the subject, you can have an idea how intellectual property is bounded in a particular product. Here we have given an example of a MacBook laptop where you can get a grant over your innovations. And in respect of that LED display, the patent will be granted. Then body of the laptop, the shape, it will be granted for design. Then Apple sign is mentioned there. Not only this device as an Apple, it may be a name, it may be a word like that. For example, you can get the name of other companies like Samsung, Lenovo, that can be registered as a trademark. Then user manual. Once we bought a product in the market, they will give a user manual how to manage that product that can be protected under the Copyright Act. Then layout of IC, internal chips. It is available in all the electronic items that will be protected under the SICL design. So in each and every product, we bound with that intellectual property rights. Without that, we cannot survive our rights. Once you got a registration in your favor in all the subjects with respect to your product or a process, you can get a right over at the time of disputes between you and the other persons. Once you got a market in your favor, that time the people will automatically copy you and make duplication and falsification of goods. That time the registration certificate in intellectual property is provided by that registry or patent office. It will be the vital document for you to get over that issues, legal disputes particularly. You may have a number of registrations in your favor. So it is a process and it will be a compulsory one. You can have a registration in the intellectual property office in each heading. First we start with patent. A patent is an exclusive right. Sorry, it automatically changes. A patent is an exclusive right granted in respect of an innovations. Here that innovation should be underlined. It should be a new one, novel one, not a existing one or discovered one. You should not copy another invention, making some slight differences that will not help you. So it should be a new one, novel one. We have to keep in mind that once the patent has been created, that time it should be a new one. Then which may be a product or process. It may be any product. For example, you invented a new engine. It is a product. Then how it performs? It should be a process. So there should be a product, and it has its own process that provides a new and inventive way of doing something, or offers a new and inventive technical solution to a problem. That process will help to solve a problem. So we have to keep in mind that a patent should be an invention, it should be a product or process. At the same time, it will help technical solutions to that issues raised over the period of time. So once that registration has been granted, and it gives the patentee gives an exclusive right over the stop others from making. As mentioned earlier, once you got intellectual property in your favor, the other persons will be forbearing from making, using, exercising, vending, and importing. So that right will grant you a protection from others to making a such product and using the product or exercising, vending, and importing. An invention for a limited period, that is 20 years in exchange for disclosing it in a patent specification, such that anyone trained in that art can reproduce the invention. Once you got a protection in your favor, it will be valid for a period of 20 years. There are limitations for each and every intellectual property rights. We are in the subject patent. Patent will be granted for a limited period of right holder to enjoy that particular patent for a period of 20 years. Then it will be in the public domain. So all the people we are as a whole at a large, we can use the product. Then the same thing is repeated, right? We exclude others using your invention. So after the 20 years, anyone can use that product for a period of limited of 20 years. We are enjoying that patent. Now we start with the examples again. These are all the inventions. You can see the left side of name of the scientist in those periods who invented new things that period of time. Thomas Alva Edison, who invented phonograph, then Alexander Graham Bell for telephone, Wright brothers for aeroplane, Louis Pasteur for rabies vaccination, Alexander Fleming for penicillin. Though we knew about all those things, they enjoyed that right over that particular period of time. Now we are using that patent. So we are getting the phonogram. Nowadays we are using smartphones and telephones. Aeroplane we are using. Then rabies vaccination we are taking as a medicine. Then penicillin also. So these kind of inventions they enjoyed that period of time, and this is the examples for after that period of limited period of 20 years. We are enjoying as a people at large. Nowadays, these are all the inventions, examples of inventions. First one, you can see that smartwatches. Nowadays, it plays a vital role. Even if we are using it as a mobile, you can we have the ringtones while we are having a call from our mobile. Then the second one, you can see a product which covers in the head of a child. The water is not going into the eyes of that particular baby. It's a kind of inventions. Then the third one in the last corner, drone. This is used in that pandemic period, and nowadays it is a vital thing for the police authorities. They can take photographs where people is not able to travel they are using these kind of instruments to take photographs and videographs. Then left corner there is a shoe. Anyone have any idea about what is that? In the next slide, we will see that what is that shoe. This is the shoe used by the late legend Michael Jackson, who invented the special shoe for making his dance easily and attractive manner. So it was granted inventions as a patent. You can see that shoe how it plays a helpful manner for his using that shoe. You can see normally he can bend forward for a 20-degree normal limit. Using that shoe, he can bend forward for 45 degrees in an anti-gravity lean, anti-gravity lean. So using that shoe, that hitch member and the base, he fix it in that stage where he performing the dances. He insert his leg into the shoe and that hitch member. Using that shoe, he can bend forward around 45 degrees. So it's a kind of invention, but better understanding we are providing these kind of examples. We'll move on to next slide. Our inventions nowadays. First one you can see the nano car. This is specially designed for the people who is having less purchasing power. The middle class people can dream a car in affordable price. The second one, hepatitis vaccine. It's a price less than $1, giving healthcare access to people with low purchasing power. And the third one is the Jaipur food. It's kind of food persons having some disabilities in walking. It was specially designed for them to have a lighter weight artificial limb, help them to walk easily without any hindrance to them. So these are all our inventions that got protected under the patent. Shall we move on to the next slide? Next subject is design. Designs may be an ornamental or aesthetic aspects of an article. Features of shape, configuration, pattern, ornament, or composition of lines, colors apply to any article, whether in two-dimensional or dimensional, or in both forms. Any industrial process or means, whether manual, mechanical, or chemical. So you can see the shape of the bottles in the first one. You can see the different kinds of shapes. It will be granted protection under Designs Act. You can see each bottle has its own shape that can be protected under the Designs Act. In the bottom, you can see a ring, specially designed ring, and then the earrings. In the third point, you can see the earrings has its own design. In the middle of that shape of that bottle with the red cork, any idea about what is the product? Yes. Without that brand name, we can identify that product. That is the shape. So using that shape, we can identify the product of that particular brand name. Then the last one, you can see the different kinds of shapes where you can fill it with perfumes and all that. So from shape of the bottle to the shape of the car, the designs will be protected. We'll move on to the next slide. This is the designs for garments. We are now college students. Once we completed our course, we may have clients from fashion designer. So once they approach you, you can have discussion with them and advise them to file a design protection for garments design. You can see that each and every photo has its own design. It is particularly noted that even the garments can be protected under the Designs Act. In trademark also you can file an application for that tailoring work, the class 40. We'll see in the next coming slides. As a treatment of materials, you can file a brand name also. We move on to the next slide. Design of set of articles. Set means a number of articles of a certain general character or be sold together or intended to be used together or wearing the same design. Not only the ring, it may be the design of a jewelry like a necklace, then earrings. It can be protected under the Designs Act. At the bottom you can see the girdle and the cup and saucer of a particular designs. You can see the right side of the top one. It has its own design of that cup. You can see that you can pour it. You can see the design over its mouth. It can be protected. Then furnitures. We have provided some normal furnitures. Nowadays you can come across the furniture shops. More and more designs you can get. That designs can be protected under this act. We move on to the next slide. You can see the shape of the bottles of a particular shampoo company. You can see each and every bottle has its own shape. There is no similarity of that particular product. So it can be protected. Now move on to the next subject, copyright. It's an exclusive right, legal right granted to the creators for their expression of idea. So once you got an idea or thoughts on your own, you can make it as a literary work, paintings, story, then artistic work, then feature films. In all the fields, it can be protected as a copyright. Copyright owner has rights to reproduce, translate, adapt, perform, distribute, and publicly display the work, etc. Once you got the right over that particular idea or thoughts, you can reproduce it. You can translate it. For example, the feature films we are preparing in other languages. The same film that can be released in local languages in Karnataka. That time they can display the work as a copyright. As we discussed earlier, registration is not mandatory since copyright comes into existence as soon as the intellectual work is created. So, but at the time of it is not a compulsory one registering a copyright. At the time of litigation, it is recommended to register a copyright for better enforceability. So, since registered copyrights have evidential value in court, simply you are making some ideas or thoughts in your own, keeping it idle will not help you because someone will come and say that they will there is a possibility of copying your ideas and thoughts. Then they will claim right over that particular ideas of your own. So for that purpose, when litigation arises, that time the certificate granted by the intellectual property rights and copyright, it will help you to success in that cases. So it is not mandatory for registering a copyright. At the time of litigation, it will help you to come across that or overcome that issues in your favor. So it is advisable to have a copyright registered. We'll see the examples in the next slide. What are all the fields you can get a copyright? First one, literary works. Literary works includes story writing, or you can write a poem, or you can have a article published in the paper, or it may be published in the social media. So you have the right to get a copyright over that particular work or idea. It will be protected. Then paintings, your thoughts, it will be reflected in your painting, so as to drawings also. So these kind of field you can get a right over copyright. Then photographs. Nowadays people are interested in getting a professional wildlife photographs where they can have a right to get copyright in their favor. As we discussed, future films can be protected before releasing. They are making some issues. Once that copyright is in your favor, that issues will be overcome. And then music and musical notes can be protected under the Copyright Act. Then choreography and yes, so as to that in the field of choreography and then sculpture, the stone carving materials, you can see in number of stone structures are making like like that. So they can also file an application for getting a right over that artistic work. Move on to the next slide. Then semiconductor integrated circuit layer. As we discussed in the first slide, it's also a kind of right. It will be controlled by the SICLD Act 2000 and SICLD Rules 2001. Original distinctive capable of being distinguishable from any other layer, design, and have not been commercially exploited anywhere. So it's a kind of product you can enjoy right over that particular product as its own originality and distinctiveness over that particular product. So it should be capable of being distinguishable from any other layer, even design, and have not been commercially exploited anywhere. So it's a kind of right enjoyed by that particular person who invented that IC, that semiconductor integrated circuit layer. He can also file an application under SICLD Act 2000, and it will be followed or procedurally followed by SICLD Rules 2001. We move on to the next subject, trade secret. Yes, trade secret is any practice or process of company that is generally not known outside of the company. So you are having a company, for example, you are making a particular product. You may have a formula to manufacture that particular product. That can be protected under the trade secret. You can maintain that formula within yourself so as to maintain your economic development over that particular uh, company, and its company. economic advantage over its competitors and is often a product of internal research and development. The following slides we are having some examples to better understanding. That trade secret can be usually used as a practice of a formula, making it without any leakage over that formula as an agreement of confidentiality. We have to keep it so as to maintain the competitors against us so that they will not get over our formula. The product are manufactured the same product. We will move the next slide where we can get an example of better understanding. First one, you can see the Coca-Cola company. This is a company where they can manufacture a particular drink which has its own color, aroma, taste, even the shape of the bottle. They are having maintaining a secrecy over that particular product. Then KFC, you can come across that KFC taste. They are also having a certain kind of recipes. What are the ingredients and the amount of ingredients to be added to get the product tastier one, so as to McDonald's Big Mac. It's a kind of sauce. It can be protected. So not only the trade secret, but these kind of recipes as a formula, they can enjoy the right over their particular product. Now move on to the next subject, trademark. As we are a law student, once you completed your course, you can practice in this field. Even you can practice patent also, but you have to pass an examination under patent agent exam. For that, not only legal background, we have science background also. So once you completed your course, uh, with the permission, I will advise that you have to practice in the court minimum 5 years and more, so that you can have a knowledge over that particular procedural law followed in the court, so that it will be extended to the practice in our office, like intellectual property office, where you can get a trademark registry. So legal background people will practice in the trademark and the geographical indications. Now move on to the subject now. A trademark is any word, name, symbol or device. As we see in the first slide, we have seen the Apple sign of that particular company. I have mentioned that not only the device of an Apple, it may be a device of other product also. At the same time, it may be a word also by the name of that company like Samsung, then Lenovo also, you can file a trademark for name. Then it identifies the and distinguishes the source of the goods or services of one party from those of others. Once the brand name has been registered as a trademark, it identifies itself and distinguishes it from others. For example, we are going for a purchase of a garment. We definitely go for a branded items rather than unbranded one. So it identifies the goods and services and itself to distinguish the goods and services from others. Then we can come across the trademark as a form of intellectual property. Once the brand name is registered, it allows a business to build public goodwill and brand reputation in the goods or services it needs. As I said earlier, once the brand name has been registered in their favor, it will create a public goodwill. So that product will be in the mind of people to pick and choose that product because of that brand registration, and it will increase the brand reputation. The registration of a particular brand will increase the brand reputation among us to choose a particular brand to buy a product. is the same point that identifies the source or origin of goods and services. And the last point, you can see the assures the brand registration will assure the customers about quality of goods and services. You can see that once we got a registered brand name, it assures us, uh, for example, Adidas, Reebok, we are choosing these kind of brand names because of they are not familiar, but at the same time, it assures the quality of that particular product. So once the brand name has been registered, it gives us the origin or identifies the source of that particular product and allows the persons to choose that product and assures the customers, we are the customers, can get a quality of goods after the registration of your brand name. We move on to the next slide. You can see the branded registered items here. From starting with McDonald's, ESPN, then Pringles, then Samsung, Facebook, Starbucks, Pepsi, Coca-Cola, Dell, BMW, Audi, Visa, Levi's. So these are all the people, they are giant in their business. They are established their product in all over the world. And these kind of registration will help them from reproduction of that particular product. So it is an important way of getting a protection by registering the goods and services. All over the world, they are having the protection. In any corner, if any falsification of these kind of goods, they can sue them wherever they got registration in a particular product. Move on to the next slide. This is the subject matter of trademark. Trademarks including service marks. In trademarks, we are dealing with classes, certain classes. For example, there are 45 classes we have to choose. From class 1 to 34, we are dealing with goods classes. Class 1 for fertilizers, chemicals, class 2 for paints, class 3 for cosmetic items, class 4 for lubricants, class 5 for pharmaceutical items. So it will goes on to class 34. Up to class 34, we are dealing with goods only. From 35 to 45, we are dealing the service classes. Suppose we are doing a business, your client are doing a business like retailing, wholesale, import, export, then they have to apply in service classes. It will come under class 35, then 36, 37, like that, it will goes on to 45. 40 for treatment of materials, I mentioned in the earlier slides. The tailoring people, that people having patient technology people, fashion designers, they can even apply for trademarks for their services also. Like that, they can get design. At the same time, they can also file a brand name registration in their uh, fashion designer service. Then 41, class 41. For example, you can take your institution, JSS Law College, and other institution also, apart from law colleges, they are doing. They can also approach us for filing a trademark registration in class 41 for providing education, training, etc. Then we move on to class 42. 42 deals with scientific and research development. You may research a software, you can get your software in your favor, hardware, like that. That kind of services can be research service, scientific and research services can be protected under the Trademarks Act in class 42. Then 43, class 43 for registering the portal services. The people who are giving a temporary food and drink and temporary accommodation, it will be coming under class 43. Then class 44 medical services, the doctors, the hospital services, they can get a registration in class 44 as a trademark. Then last one, 45, it's belong to us. Since we are the lawyers, we can also have an association or associates or a law firm. We can register our firm in class 45. Legal services. Legal services coming under class 45. Other services like social services and doing non-monetary or non-profitable organization, they can also file an application in class 45. So not only the books, it includes trademarks, includes service classes also. Then second point, collective marks. Suppose your clients combine together form an association. That association of person may be a firm, a partnership, or a company. So they will be collectively enjoying the right over that particular mark is called collective marks. Each and every person have a right over that particular trademark as a collective mark. Then certification of marks. You can come across with the certification of marks granted by the government of India, like ISI, ACMAR, then silk mark. Silk mark you can see in Mysore. In lot of places, even yesterday I come across that Kaveri silk emporium, like that I have seen, where it is affixed that silk mark in that shop itself. Then wool mark, that sweaters we are using in the winter time, that the quality of that kind of sweaters can be granted wool mark. Like that, it goes on. We can see the examples like the BAS also. The next slide we will see. Then tagline and slogans. You have any idea about the tagline? I will give an example in Pepsi. Yes. A Dil Mange More, that can be protected as a tagline. And slogans like just do it in Nike, that can be filed an application for granting registration. Yes, you can create your own ideas as a tagline. Along with that trademark, the brand name, you can use it as a tagline or slogans. Along with that, you can get a right over as a whole. Unless you want separately, you have to give your user. Once that brand name like Pepsi has been registered, they can go for a tagline alone also. So if we have to keep in mind, not only the brand names, the taglines and slogans can be protected. Then non-conventional marks like a smell mark, scent mark, then sound mark, then moving mark. The moving mark is the example, the zoom in view of the female statue at the beginning of every colonial pictures that has been registered in USPTO, United States of America Patent Office. You can come across at the time of the starting the Hollywood films, a picture will come. We'll see in the next slide for better understanding. For non-conventional trademarks, sound mark and moving marks, we'll see in the next slide. First one, you can see the colonial picture. This is the motion pictures that has been registered under the category of moving picture that has been granted by the USPTO office. Then sound mark, the roar of the lion, Metro Goldwyn Mayer trademark. The roar of the lion as a sound mark has been registered. Then shape of the bottle, Coca-Cola bottle also filed an application for its own peculiar and unique style of shape. As we discussed, the Pepsi, Dil Mange More has been registered. The Bureau of Indian Standards, BA mark for certification trademarks. Then service marks like Naukri.com, Google, they are also enjoying that right over particular trademark as a service mark. Then how to advise your client to get a good trademark registered? First, we have to choose a mark with the following facts. First, it should be distinctiveness. The mark, the brand name should be has its own distinctiveness. Suppose you are having a product in your mind. For example, your client is manufacturing or selling a product like salt. You cannot or he cannot claim that salt as a trademark in the name of brand name like pure, best, quality like that. It should not be a disclosure of that product. The product will not speak its quality. You cannot file an application for pure or salt. I'm saying, for example, to better understanding, you have to advise your client, don't come with the words pure, better, best, quality like that. These are all the laudatory terms which cannot be acceptable as a brand name. So they have to choose a brand name, and at the same time, it will not affect the provisions of Section 9 of Trademarks Act 1999. Section 9 says, as an absolute ground, the mark will not be granted in your favor because of 918, 903 objections, like non-distinctive characters and descriptive words. Then it should be inherent and acquired. Inherent means the mark itself has its own inherentness to get a registered trademark. Then acquire distinctiveness. Once your client has been using the mark for a period of time, he decided to approach for getting a trademark registration. He may have the documents like bills, receipts, invoices, so that to maintain the records as well as they have to prove themselves they are in the market. So he acquired distinctiveness over that particular product. It will help him to get a registered trademark using that user. So and so period I am using the mark, they can apply our approach our office, file an application under the Trademarks Act. Along with that, he has to prove the user. Then not deceptively similar mark. We have to avoid not deceptively similar marks. Copying the earlier well-known marks, we have to avoid those things. We can get the examples in the next slides about the not deceptively similar mark. Then honestly adopted and foreign. Once, suppose a person is using a mark in Mysore, the same mark has been using in other states. That time there is no relation with each other and they have no knowledge about each product or using a brand name. That time, these kind of provisions honestly adopted will be come into force. Based on that, we can accept our their applications, and with conditions, area restriction like that, we can give. Not similar to already existing mark. The trademark should not be similar to earlier existing trademarks which may be registered. So before accepting a new mark, it is advisable to have a search conducted and evaluated. It also avoids unnecessary litigations. Once you have a client in your hand, you have to advise them, or otherwise you have to visit our website. Please note down our website ipindia.nic.in. Yes, sir. They are noting ipindia.nic.in. This is our website address. Once you open that website, you can get all the subjects like patent, trademark, designs, geographical indications like that, copyright. Once you choose that public search, in public search, you can get a patent also. go for a trademark, where you can get a portal which has this list of prohibited marks, then well-known trademarks, then non-proprietary names, and then class details. So that public search in trademarks deals with these kind of charts. You can have the knowledge over there. You can visit our website and go to public search. You can get that particular things in that way, where you can view your brand name. As a public search, you have to put your decided brand name, then you have to give class details. As we discussed, there are 45 classes. Which class it belongs to, we have to decide. In that, we will get a search. There you can get a list of registered trademarks. So, by getting the details, you can advise your client saying that already registered brand names are there. You can avoid or you can make some amendments to get your brand name registered. So, it is advisable to have a public search before choosing a brand name. This is the point for deceptively similar trademarks. You can see that they have copied it from first one, Playboy, they have mentioned as Van Boy. These are all the examples to better understanding of deceptively similar marks. Then they have mentioned Nike as Nike and slight deviation of the tick mark. These are all the things to be avoided. You never get registration over these kind of products or brand names. Then you can see the color combination of KFG. You can say that it will be the KFC. They had made some alterations. Then Puma, they have mentioned as foam. So these are all the things as a lawyer we have to avoid, and we have to advise the people. You don't bring these kind of trademarks. It is not useful for you. Now we move on to the procedure how to file an application of trademarks. The Act called Trademarks Act 1999. It is prescribed the rules and the procedure mentioned in the rules, Trademarks Rule 2017. Suppose you are a application, the client, your client will be an individual or startup or small enterprises. You can get a fees exemption of 50%. The startup and individuals small enterprises has to provide the certificate from the uh, MSME certificate as well as the startup certificate. They will get a relaxation of fees of 50%. Suppose you are filing an online application, the total fees is 10,000 rupees. If they are individual, they are startup or small enterprises, they will get half of that amount deduction into 5,000. If you are filing through online, for filing an application through online, you have to get a digital signature in your name. Then you can access over that particular procedure of filing an application through online. Another 10%, that is another 500 will be deducted for online application. So totally 4,500 will be the fees for the individual startup and small enterprises. The form is called TMA. And mode of filing you can file through online or offline. If you are choosing offline, A4 size paper with the type written or printed in Hindi or English. Since we are the central government office, it should be in Hindi or English. You can file in your regional languages like Kannada also, provided you have to give translation of that particular brand name. So we will allow your application based on the search report, and then that examination will be done there. Then statement of user. As we discussed, acquire distinctiveness when the client has its usage for a particular period. They have to provide invoices, bills like that to support his case. He is in the field. then an affidavit. So to support that evidence is valid one, he has to sworn an affidavit stating that so and so period I am started, I am using continuously, and these are all the evidences I am filing to support my case, and the affidavit should be notarized by that notary public. So these are all the things we have to follow in filing the procedure of a trademark application. Once you file an application before our office, you can advise your client to put TM, that is trademark, which means it is pending with our office. So once you got a registration certificate, you can ask them to put letter R in a circle. So you got a registration in your favor and the certification has been delivered to you. That time only you have to choose that letter R in a circle. If you are doing business without registration certificate in your favor, but you are using this R in a circle, is an offense. So it will be prosecuted. So keep in mind, you have to follow the procedures. Once the trademark or brand name has been registered, you are allowed to use that letter R in a circle. You may come across these kind of letters in day-to-day life, even water bottle. For example, Bisleri, you can see that the R circle is there, just top of that I letter. You can come across and see that letter. Move on to the next slide. Renewal and post-registration management. Renewal means like patent, it has 20 years validity. After that, no renewal will be available. But in trademark and geographical indication, your rights will be continuously, indefinitely you can use that right. Provided you have to file a renewal application periodically once in 10 years. It can be further renewed indefinitely. That's why I'm saying 10 years. Each 10 years you have to file an application for renewal. Trademarks can be transmitted by operation of law, license, or assigned by act of parties. Like other assets, properties, maybe movable, immovable properties, the trademark intellectual property can be transmitted to others, except with geographical indication. If you are having a registered trademark in your favor, suppose your client wanted to transfer it to other person, you can do it by following some procedures. It's a kind of assignment deed. Both the person, that the registered proprietor and the subsequent proprietor can file a assignment deed with the terms and conditions, which includes consideration. Without consideration, you cannot transfer, and then the consideration should be acknowledged by that assigner. Then there should be an mentioning of an term like the trademark has been transferred with goodwill. Then it should be filed by an affidavit, followed by an affidavit by the person who is holding that right, that there is no case is pending before any court of law, making sure that the mark is not with any encumbrance. So these are all the steps to be followed by transferring that property to someone else. So while transmitting these kind of properties, it should be a valid trademark. As you mentioned, it should be renewed periodically, and the validity will be intact. So it should be a registered trademark, and it has its validity. Then it will be transferred to other person. The Trademarks Act 1999 also provides administrative, civil, and criminal remedies. Once you file an application before our office, it can be for administrative reason. I'm saying it can be examined by our office whether a similar trademark has been there. The examiners will scrutinize your application, and then if anything is there, they can object your application. Preliminary objection will be there. So as to you have to reply it, based on the reply, it can be accepted. Suppose there is no similar marks in that register, it can be directly accepted. Once the mark is accepted, there is a period of 4 months we are granting. It will be published. The trademark brand name has been published in our journal, so it will be viewable by the public at large. We are granting 4 months period, so as to anyone affected, they can file an application for opposing that trademark. Suppose your client file an application for a particular brand name, the other person also using the same name, may be similar, not identical, they can approach us for opposition. So that is called administrative reasons. The opposition proceedings will be started there. Then civil, once you got a registered trademark, the other person is falsifying your trademark, you can file a civil suit against that man. If you are a registered proprietor, you can file a infringement suit. Suppose if you are a unregistered proprietor, you can file a suit for passing off. Then criminal remedies. Not only civil and administrative remedies, criminal remedies also available for you. Once the falsification has been found by that particular brand owner, he can file a police complaint in the local jurisdiction. Based on that complaint, that DSP, the range of that DSP, is Deputy Superintendent of Police or Assistant Commissioner of Police, not below the rank of DSP, can approach our office asking us to provide a opinion under Section 115 of Trademarks Act. We will provide a opinion whether the mark has been falsified. Based on that opinion, they can search that premises. The police can seize the products and falsification of products. Then even they can arrest that person who is doing wrong thing. So we have to keep in mind, based on the opinion only the police can act. So they have to approach us for the opinion whether they are doing the falsification or not. Now the last subject, geographical indication, which will be interesting one. Geographical indication is a sign used on products that have a specific geographical origin and possess qualities or a reputation that due to that origin. The goods here, like service classes, it is not available in geographical indication. In trademarks, we come across the service classes from class 35 to 45. It is not available in geographical indication. Only goods classes 1 to 34 is available, and the goods which carries its own origin, they can file an application for right under geographical indication. For example, champagne from France, Scotch whiskey from United Kingdom, Napa Valley wines from USA, and Indian product Darjeeling tea from India. These are all the well-known examples. For example, tea is the product here under class 30. It has been filed and it carries its origin, that is Darjeeling. Darjeeling is the name of the place where that particular tea is available. So the goods carries its own origin with the product. Nature of goods. Geographical indication has been divided into 3 categories. First one is agriculture product, natural product, and then manufacturer. Manufacturers and goods has been further subcategories as handloom, textile, goods of industry or industrial goods, foodstuff, and wines and spirits. First, agricultural goods, we have the examples. You can see basmati rice, Darjeeling tea, Kangra tea, Alfonso mango, Uttarakhand tejpat. These are all the agricultural products. They got registered in geographical indications. Then natural goods. the goods which are available for us naturally will be registered under the category of natural goods as a geographical indication. Here the natural product is marble. Marble we are getting naturally. Then the name of the place, as I said, the product will carry its origin, the name of the particular place where it's come from is Makrana. Makrana is the name of the place in Rajasthan. So, under category of natural goods, Makrana marble will be registerable. Then handicrafts, which comes under fire pottery, then stone sculpture, wood carving, metal craft. We can see the examples: blue pottery of Jaipur, then Mahabalipuram stone sculpture. You can come across Chennai, you can see the sculptures in olden days. The Pallava kings has been created that kind of sculptures. Then Konark stone carving, Agra marble inali, and your state item, the goods, Channapatna toys, has been registered, granted geographical indication. Then in the heading of handloom textile embroidery, Banaras sarees and brocades, then Pulkari, Pochampalika, Mysore silk. Mysore silk has been granted GI. The product is silk products and the name of the place is Mysore. So that GI always carries its own origin. The product will carry its own origin along with the name of the product will be registerable under GI Act. Then Pathan Potala, Kashmir Pashmina, Mughal silk of Assam and Kashmir Susani craft. Then foodstuff. Foodstuff from Dharwad Peda. Peda is sweet and the same is categorized as goods. This is the place, Dharwad. You can, in your state only the place is situated. Dharwad Peda has been registered. Then Halim from Hyderabad, then Rasgulla from Bangla, then Bhuja from Bikaner, and Ratnam is same. Same is the food item here. Then the place, Ratnam is the place of that particular area in Madhya Pradesh, has been registered as a GI. Then industrial goods. Industrial goods, Coimbatore bed grinder in Tamil Nadu are famous. Then scissors. Scissors in Meerut are registered under the geographical indications. Then Kannu chapter. So these are the products which got its geographical indication in their favor. Who can apply? In trademark, we discussed that any individual can file an application for trademark applications. Here, only the group of persons, association of persons, only the association of persons will file an application for registering a GI. That GI can be under GI 1A Form 2 1D. The fees will be 5,000. Since the individuals are not allowed to file an application under the geographical indication, the individual can file an application as a authorized user. Suppose a registration has been done in GI. If that person is from that particular locality, he can approach the office getting a permission as a authorized user. Be concerned with that particular manufacturing association. We will grant him a license to use that product as a authorized user. So individual cannot file an application as a GI. Only authorized person can file an application. Then the fees will be 5,000 per class, and the GA 3A is the form for filing an individual as a authorized user for rupees 10 for filing such an application. Like in trademarks, GA will be indefinitely you can enjoy that right, provided you have to file every 10 years a renewal application. Then GA authorized user also enjoy that right as a GA owner. The authorized user can initiate infringement actions in court also. So not only that manufacturer association, once the person individual who got a authorized user from getting a license from that particular association, he can also file a infringement suit. So as to criminal remedies also available against falsification of GA. As mentioned in trademarks, GA also granting criminal action, then administrative action and civil actions also you can file. The important point is GA shall not be subject matter of assignment, transmission, licensing, pledge, mortgage, or any such other agreement. As we discussed, as a intellectual property, trademark can be transferred to other person for consideration. Here, the GA cannot be transmitted to other person in any format, even as a assignment, as a transmission, as a license, pledge or mortgage, or any other such act. So we have to keep in mind, differentiate with trademarks and GA. We have to follow the rules. These are the examples of famous geographical indications. First one we have seen the Darjeeling tea. It will be repeated again because this is the first tagline. That tag geographical indication tag has been branded by India. Then natural goods, Akrana marble, Bobli Veena, Pastor Dokra from India. Then Venkatagiri handloom sarees. Then Narayanpet handloom sarees. Then Malli. Malli is the flower, you know that. It is famous in Madurai, in Tamil Nadu, the temple city. It has its own origin of Malli cultivated there. That has been registered as Madurai Malli. Name of the place is Madurai and the product is Malli. So it carries its own origin or name of that particular product, where it's come from. Then Wayanad Jeera rice. Then Surat Jari crab, oranges from Nagpur, then tea from Nilgiris, Darjeeling tea repeated here. Once we consider these things to consider a geographical indication, we have to consider the nature of the particular soil, climate, the taste of that leaves, aroma of that leaves, all you are considering that all the things we are granting geographical indications. Then natural item is Akrana marble from Rajasthan. Ratnam is same. The name of the product is same, and the name of the place where it's come from is Ratnami. The name, the city in Madhya Pradesh. The world famous silk from Kanchipuram. Kanchipuram silks are world famous silk sarees that has been granted a GI. Other examples, first one is Kanyakumari cloud, then Laddu, Tirupati Laddu. Laddu is the product here. The name of the place where it's come from is Tirupati Laddu. Then Matlam of Palakkad. Your name, your place name, Mysore Sandal soap that has been registered. The product is soap from Mysore has been granted registration. Then mat, the Patamada Poi's mat that is been famous in Patamada. Name of the place is Patamada. Then Dindigul locks. Dindigul is the name of the place. Not only it is famous for locks, it is famous for biryani also in Tamil Nadu. Then Kovilpatti Kadalametta, which is a kind of groundnut burfi, has been granted. Then Sirumalai in banana, and then Kodaikanal Malai Pood. This is the garlic cultivated in the Kodaikanal. They got the right. Then other states, Kutlis of Rajasthan, Goblins of Madhya Pradesh, Bengal Chitra, chariot paintings. You may aware of the Pitri ware from Karnataka. then Burley paintings, then agricultural products, Magi Pond, Devanahalli Pamilo, Apamindi Mango, Kashmir Saffron, Lychee of Bihar, and oranges from Coorg. Coorg is from Karnataka. These are all the products from your area, that is Karnataka. Nanjangud banana has been registered as a geographical indications. Mysore sandal agarbattis, then the chip of arts, Chennapatna toys, Coorg orange, that is beetle leaf, then cotton. These are all the products that have been registered categories of geographical indication from Karnataka. We end the program here. If you have any questions, please ask me. I'm waiting for your questions. Thank you. Questions, sir? Second row, second row. Okay. Yes. All the others are conventional. Yes, and in respect of sound, that is smell, these are all the. Yes,
Can you explain about conventional trademarks?
yes, except that the non-conventional marks, many marks can be registered as a conventional marks. The sound mark, smell mark, these are all non-conventional trademarks that can be protected. Any question? I think it is useful. The class is useful for you. So thank you once again. Thank you very much.
Thank you, sir. It was indeed very enlightening. As we have reached the end of this event, I take this opportunity to propose the vote of thanks. I extend my heartfelt thanks to our chief guest and the resource person, our Venkatesan sir, for gracing the occasion. On behalf of our institution, I thank the Trademark Registry for associating with our college. I express my sincere thanks to Professor K.S. Suresh and our beloved principal, Dr. S. Raju in their absence here. I thank Jagdish sir, the teacher coordinator, for his valuable support. And lastly, I thank one and all for your cooperation. I thank one and all for your cooperation throughout the program and your valuable participation in making this event a grand success. I request Bhavna, I request Jagdish sir to hand over the token of gratitude to our resource person.
Thank you one and all for participating in this program. Very shortly, you will be receiving the certificates. Thank you.